All right, give me
Okay.
1 second.
All right, so Dylan, are we recording?
I'm going to in 1 second.
All right, let me know.
All right, you're good to go.
All right, great. For the duration of the coronavirus health emergency, Village Hall is closed to the public and meetings are held with participants at remote locations, connecting to conferencing software provided by Zoom.us. Members of the public are invited to view meetings live using the Zoom client, which also allows them to raise a hand and contribute with voice and video when they're invited to do so during public portions of the meeting. It's very important that anyone who would like to provide testimony this evening must be able to join via video. Testimony must be sworn in, and we need to see you raise your right hand. So if you're listening and you don't have access to video, please make sure you're able to do so. We're going to call the meeting to order and begin by reciting the Pledge of Allegiance. I pledge allegiance
Pledge allegiance
to the flag
of
the United States of America,
to the republic,
to the republic for which it stands,
One
one
nation,
nation,
under
under
God,
God,
indivisible,
indivisible, with liberty and justice for all.
Okay, and Jane, if you can, let me read this statement first. Dan, good evening. Adequate notice of this meeting has been provided by posting on the bulletin board in Village Hall, by mail to the Ridgewood News, the Record, and by submission to all persons entitled to the same as provided by law of a schedule including date and time of this meeting. Please note that a curfew of 11 p.m. is strictly adhered to by the zoning board. For this evening, we only have one application. We would like to not start any witnesses after 10:30 p.m. and we would like to be able to institute that 11 p.m. curfew if at all possible. Jane, roll call, please.
Niagara,
Here.
Greg Brown, Gary Negritz, Diana Rule.
Here.
John Pepetro,
here.
Isaac Lebo, Matthew Bandel,
Here.
Dan Perlman,
Here.
Michael Pickles.
Here.
Okay.
Okay, so now we'd like to approve the minutes of March 23rd, 2021. If someone could please make a motion.
This is Matt. I'll make a motion to approve the minutes.
Second.
Thank you.
Diana Rule,
Yes.
John Pepetro,
Yes,
Matthew Bandel,
Yes.
Michael Pickles,
Yes.
Chairman Allegra.
Yes. Okay, so let's skip down to resolution memorialization. Can we go through that? And then we'll get to the non-agenda items.
Okay, I have the Sullivan Resolution for 409 Colonial Road. Matthew Bandel
Yes.
and Chairman Allegra.
Yes.
And we have the Anadu Residence, 155 Highland Ave. Diana Rule,
Yes.
John Pepetro,
Jane, I denied that.
oh, you're right, I'm sorry.
Quite all right.
And Matthew Bandel.
Yes.
Okay, that's it.
Okay, thank you, Jay. Okay, so now is the time for non-agenda items. Are there any board members who would like to make a comment on a matter not on the agenda this evening? There being none. If you are a member of the public and you would like to make a comment on a matter not on the agenda this evening, please raise your hand and Dylan will let you into the meeting.
I'm not showing any.
All right, great. So Gary, is he still not here, Dylan?
He hasn't joined yet. The minute he joins, I'll bring him in.
All right. Well, we have a quorum, so we might as well just get started. He could just listen to what, if assuming this goes longer, he could listen. Bruce, if this were somehow to wrap up tonight, can you vote if he shows up a few minutes late?
Yeah, I mean, he'd have to participate at the beginning.
Okay, just double check.
So we have 6 members, Jane?
Yes.
Yep. So we're good to proceed. Yes?
Okay, so before the applicant starts, let me just start by saying this is a new application. The applicant had come before the board once before. That application basically was withdrawn. There were some questions about notice, etc. So this is fresh. So anything that has been submitted in the past is not something to be considered by board members that happen to be on the board at the time the application had previously come forward. For board members and members of the public, this is not an application for a variance. This is an application for basically a certificate of non-conformity. There is a section in this municipal land use ordinance, section 68, that states in part that any person that has an interest in the property, be it a purchaser, mortgage lender, the owner, or an applicant as defined in the municipal land use law, may apply in writing for the issuance of a certificate for the use or structure, stating basically that it existed before the adoption of the ordinance, which rendered the use or the structure non-conforming. The applicant shall have the burden of proof. The applicant will make that application to the zoning officer within 1 year of the adoption of the ordinance that created the non-conformity. After that, you no longer can go to a zoning officer, but then the applicant has to make the application to the zoning board of adjustment. So once again, this is not a variance application, so it has nothing to do with section 70, but rather it is under section 68. And the burden of proof is with the applicant, and the applicant has to show A, that the use was non-conforming before the adoption of an ordinance, and B, the applicant has to show that it's been a continuing use and has not been abandoned. That's the basic burden of proof for anything under a section 68. So that's an overview of the application. I've had the opportunity to review the notice that was sent out by the applicant for this meeting, and it meets the requirements under the municipal land use law for proper notice for this purpose. So that's an overview of the application. I'll turn it over to counsel for the applicant, Mr. Garibaldi.
Thank you, Mr. Whitaker.
Actually, Mr. Garibaldi, just for the record, if it's okay, I'm going to announce the application, just one of the things we do. And then as soon as I do that, we'll turn it over to you.
Thank you.
Okay, so we are going to begin with new business. This is the matter of Eric Ruse. It's an application for certification of non-conforming use at 560 Route 17 North, Block 4704, Lot 6, in an R125 zone. Sorry about that. Continue, Mr. Garibaldi.
Thank you. Good evening, all. My name is Robert Garibaldi, firm of Garibaldi and Garibaldi. I'm here as a counsel for the applicant, Eric Ruse, for the purposes that Mr. Whitaker had just set forth with regard to seeking a certification from the board, excuse me, as to the nonconformity of the uses on this particular piece of property for a protracted period of time. Concurrent with the application, I have submitted an exhibit list, which our sole witness, Mr. Ruse, will go over a number of them. Key points for just historical purposes, and I understand that this application or prior application did not specifically request a certification, so therefore the board has not previously ruled specifically on this particular request, but my exhibit lists, specifically A2, A3, A4, are the resolutions of a prior application in 1999, and then accompanying transcripts of testimony. I'm not looking for the board to have to exhaustively go through this, but just historically, there's reference, as Mr. Ruse will also testify tonight to, as to what took place with this property back in 99 and 97. And he'll also bring this board current through 2021. Also of note to the board in the resolution of 1999 was a finding by the board at that time, specifically on page 10 in finding of number 2, that the use, which was determined to be a nursery and a garden center, pre-existed the ordinances of the Villa of Ridgewood, and traditionally nursery uses were deemed compatible with residential zones. So the board in 1999 did give recognition based on the testimony presented then that there was a pre-existing nonconformity as of 1999. But again, I'm cognizant of the fact that that board that evening was not specifically requested to make a certification, but I believe that their findings of fact are at least of note to this body. So to that end, I'd like to bring Mr. Roos in to testify to the historical uses on the property, of which he has a long history that hopefully will be of interest to the board. So
Mr. Roos, if you would raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth and nothing but the truth?
I do.
Please proceed.
Mr. Roos, could you identify your interest in the property located at 560 Route 17 North in Ridgewood, New Jersey?
Yes, it's been in my family since approximately 1900. My grandfather purchased the property, and then it was later on left to his siblings, or actually his son. They divided the property up, and it's been a nursery and a garden center since, I will say, to the best of my knowledge, the early 1920 at best, at the latest, if not sooner. We grew nursery stock there, and we sold nursery stock there. And I've been on this property since I was 2 years old. I could walk.
Beyond the selling of nursery stock during this, again, to the best of your knowledge, and I know it dates back quite a while ago, but can you further describe any other uses that existed as far back as your recollection as to your family's operation at this particular site?
Like I said, originally we grew nursery stock there in the back and sold it in the front. And my uncle sold things, like I said, grew in the back and sold in the front. And then he leased out to several different people over the years, including my mother and father. Back in the early 60s, he had several landscapers that parked their trucks in the back.
If we can hold that for a second, because I know you have a detailed list of historical uses from the 60s forward, so I'll have you go through that schedule in a moment. I'm looking mainly prior to that. Any uses beyond merely nursery, growing nursery stock and selling nursery stock? Well, I mean, it was deemed to be a garden center. What else was encompassed in a garden center?
We did everything that would a garden center would be. That's all we ever had there, and that's all we ever did there. That was the nursery. We called it the nursery. That was it. You grew plants, you grew vegetables, maybe for something a little different in the summertime. Other than that, it was just strictly retail, wholesale, and grew nursery stock.
Okay. Attached as Exhibit A11, which I'd like to introduce, did you not prepare a historical uses of the property to your recollection from 1960 forward?
Yes, sir.
You have that document in front of you?
I don't have it right in front of me, but I can definitely speak to it.
Okay. To expand on, or at least to assist the board, from the 1960s forward through the 2000s and up to 2010, you've gone through and provided a detailed list of additional names of people and activities that they provided on this particular site during these periods, such as in the 60s, the Myers, the Warren Sard farm. Were these all tenants of your aunt and uncle?
Yes, they were. Yes, they were.
And they pretty much operated what type of businesses on this site during those periods?
Nursery, garden center, all along those lines. It was always the same things.
So nothing deviated beyond all the time, no matter who was on site, whether it be owner operated or tenancies. It was always operated back, as you said, to the early 1900s as a garden center and nursery, until the time came that ultimately you became in possession as owner of this particular piece of property.
Yes, sir. Yes, that's the way it was.
And how did that come about, and when did that come about that you took title to the property?
My uncle passed away And then
In about what year?
1989. And then my aunt passed away. And I became the sole owner of all the property.
And that was about approximately when did your aunt pass away?
1993, January
93.
1993.
And then at that point, by what? By inheritance or by purchase? You
No,
by
by
inheritance?
Yes.
So at that point, you took over and operated the business. And what were your activities from 1993, 1994 until you ceased your operation?
I leased it out to several different nursery fellows that lease on a yearly lease from me, and continue that operation until I got involved myself there in 1997. And I had a partner for a few years, and I ran it myself until 2009.
And when you say you rented it out or leased it out, were these on a basically a month-to-month,
Yearly lease.
non-written leases? There were oral agreements?
Well, the yearly,
Other than for Mr. Wiggers, which we have presented, but
yes,
these were mostly month-to-month oral agreements that you had reached with all of the individuals noted in A11.
yes,
So I'm speaking more contemporaneously in the 2000s, which is MJM LLC, Dunker, Novak, Madanish, and then GB Landscapers, companies such as that.
yes,
And then prior to that,
yes,
and then in or about 2011, which we have attached as a Exhibit A9 is a written lease agreement that you executed with Mr. Wiggers. Is that not true?
that's correct.
And that lease ran up until when?
About 2 years ago.
And
2 years ago, which would be-
the also attached to as an Exhibit of A10 is a CCO, which you were able to obtain for Mr. Wiggers to operate on that site. Is that not correct?
That is correct.
And that the conditions of the CCO, and I'm reading as in remarks, and I'll read to you, and just to make sure this is accurate, that there'll be no increase in the non-conforming use which has existed is permitted to occur with this new merchant, and no signs without permits. So
Correct.
it was your understanding that as you described a nursery and gardening center, Mr. Wiggers was taking over and operating that on that business for that 8-year period of time.
That's correct.
Attached to the lease was a Schedule A, and you identified a series of permitted uses within the lease. And I just wanted to go on record to indicate if these uses were operated by him as well as other tenancies on this property during the period of time of your ownership or your aunt and uncle's ownership, which would designate the type of nursery and gardening center that has a sort of a generic definition, but this is more specific to the activities that took place on site. So I'm just, again, I don't believe you have it in front of you, but I'll just go down briefly, is that it was the sales of trees, shrubbery, and flowers,
Correct.
sale of pots and ornamental garden items,
Correct.
sale of decorative stone, pavers, and railroad ties,
Correct.
sale of soil and plant, lawn, and garden food.
Correct.
There was an office for his design landscape, which is a part of his operation. And then the related parking and storage of landscaping vehicles and equipment,
Yes.
sale of planting bed materials, garden tools, and then Christmas trees, Christmas blanket, and roping.
Correct.
And then last was a retail sale of firewood.
Correct.
Was there any other activities, now that I've refreshed your recollection of prior uses on the property? Anything else that would have struck you as things that you would have done or your aunt and uncle would have done beyond as was described in the Wiggers lease?
No, no, that's everything pretty much a garden center does. I mean, if you wanted, there was absolutely no power equipment sold there or anything like that. It was strictly all, for lack of a better terminology, it was all natural products. There was nature that were grown and sold there for the use in your yard and improvements.
Again, we're trying to create the historical uses. Were there any structures on this property during the period of time of your aunt and uncle's ownership through your current ownership of the site?
Yeah, there was a small office in the front, and we have a couple small, for lack of a better, storage shed. Nobody's in. All you do is you store tools in there, maybe fertilizers, things of that nature, things that couldn't be out in the elements.
And that has existed for how long a period of time, to your recollection?
Past 50 years.
Okay.
I mean, they're movable storage. They're movable sheds. They're not permanent structures.
They're more personal property rather than permanent? They're not
Yes.
affixed. Are they affixed to the ground or into concrete?
No, they are not. They are not.
Are there any other tenants on the property now that Mr. Wiggers has left
Yeah,
existing at this time?
I have 3 other tenants there now.
And what are they? Again, they are in the garden
Yeah, they're
business and landscaping business
landscape.
only.
Yes.
And no other uses have existed on this property. No homes were ever built in the past or any industrial, commercial uses beyond, again, your commercial and retail garden center and landscaping business.
Absolutely not.
For additional assistance to the board, we have also pointed out in A12 some historical photographs that we were able to obtain off a website, and they're so marked. All of them go back, I believe, to 1931, indicate a vacant piece of property. And just again, your recollection, having reviewed these ancient photographs, that was the condition. The condition of the property has been a vacant piece of property used only for this garden center and landscaping businesses.
I mean, obviously I wasn't around in 31, but during my lifetime, it was definitely, it's always been garden center nursery.
So it's consistent.
Yes.
And as I indicated before, the resolution of 1999, the board at that point appeared from the resolution to have noted that the use had been a pre-existing nonconformity in 1999. And what you testified to is that nothing has changed since that period of time through your testimony today, that there has been any deviation of the uses. Perhaps there has been a cessation of some of the use because the property, if I'm incorrect, correct me, the property has been under contract to be sold. And as you indicated, Mr. Wiggers has removed himself or been removed from the property in 2019.
That's correct.
But there are current subtenants or tenants on the property continuing the uses, and it was never your intent, nor have you ever demonstrated any activities that would show that you would cease the non-activity of use, the pre-existing non-conforming use, up to the point of this application for a certification.
Yes, no, it's only for a matter of sale, and I just want that's it. We want to continue as a nursery. We want it to be a nursery. It's ideally suited to be a nursery. It's just, I mean, it is what it is.
And it's never changed for as far as you know, back to the inception of your family owning this particular piece of property.
No.
The additional exhibits that we have put through, I just wanted to make sure that again, we have also submitted your certification of A13, which again, I've submitted the transcripts for the edification of the board, but I want to make sure that you certify that the testimony you gave in that 1999 and 1997 proceedings were true and accurate then, and they remain, to your knowledge, after having reviewed them again, true and accurate as of this date.
Yes, they are.
So if the board elects to review them, they know that the information has been certified to be accurate then, and that certification runs through tonight's hearing.
Yes, yes, absolutely.
Well, are you aware of other efforts that we've made in a demonstration of the historical use of this property, insofar as requesting even your agent, Mr. Gilsenan, to seek out records within the Ridgewood Village Hall?
Yes, I am aware of that.
And you're aware that in his own certification, which has also been appended to as an exhibit, due to the age of this property and candidly the water damage that was done to the village many years ago, it became a unsuccessful effort to find any historical information beyond what we believe that will be submitted this evening as evidence before the board.
Yes, I'm very much aware of that.
So since our last hearing, which Mr. Whitaker has indicated is not, the information is not before the board, efforts have been made to try to come up with specific definitive information, but beyond what we are submitting, which is your recollection that there was no written leases beyond Mr. Wiggers. Everything else was done on a month-to-month tenancy, but there has been ongoing, consistent, uninterrupted business activities at that site through present.
That's correct.
There is also appended, and you did pay for an updated survey from Lepatka and Associates, which was dated in I think 2020, which we have submitted also as an exhibit to the board. And again, the condition of the property shows as being, other than for these sheds on site, there's no other activity. The site is, as described, is primarily a vacant piece of land that has been used, and the intent is of your contract purchaser to continue to use this as a nursery and garden center, which is why we are here this evening.
That's correct.
So it is designed for a particular purpose in order for this process then to be transferred over, with the understanding that whatever requirements of the village would be for his operation to receive a CCO as Mr. Wiggers received, or any other requirements of the village building department or zoning board or zoning regulations, would then become the responsibility of the contract purchaser. It is not our responsibility to present anything to the board on their potential future use. They're just going to assume what prior uses you had enjoyed and will hopefully continue to enjoy after this evening. Is that correct?
That's correct.
Surprisingly, I don't believe that there's any historical documentation that we have, and I don't believe it's, and Mr. Whitaker, I'll defer, but I think the testimony of Mr. Roos is what we are going to rely upon. I don't think it's necessary for me to repeat or go through the prior testimony of the prior hearings, but I do incorporate them as a reference to this particular board. But the continuation of this use has been going on for almost 90 years, and his testimony is short and to the point, and I don't think there's any other evidence that I have been able to glean, nor we have been able to glean, beyond his personal recollection and the leases and the information in the prior transcripts, with the certificate of continued occupancy also as an action of the official action of the village affirming its nonconformity, and then would present that as the basis for our request for certification.
Does that conclude your testimony, Mr. Garibaldi?
I don't believe Mr. Roos has anything beyond that to present.
Okay,
No, as I would concluded, yes.
Mr. Chairman, it'd be appropriate now for questions by board members.
You're muted, Sergio.
Thank you. Let the record show Gary Negritz joined at 7:55. We'll go around. Diana, questions?
All set.
Okay. Dan, questions?
Not at this time, Mr. Chairman.
Okay. Jonathan, questions?
Yes, just one of Mr. Ruse. You said you have 3 tenants there now, and what are they doing with the property? What are they using the property for, the 3 current tenants?
They park their vehicles in the back. They have
I see.
trucks and trailers, and they just park them in the back.
Okay, just for parking the vehicles. And is your agreement with them verbal or some kind of written lease?
It's verbal.
Okay. Thank you. That's all, Mr. Chairman.
Matthew, questions?
I have no questions.
Okay. And Gary, questions?
Actually, I just have a question for Bruce, clarification. Having read through this voluminous submission, it would appear that sometime in 12, Mr. Wiggins left, and so since then, from what I gathered, just the testimony I just heard, the property has been used by people who might be in related industries, but it was not operated as a garden center or nursery. And so what defines uninterrupted use, which I believe is a criteria for certifying a non-conforming use, pre-existing non-conforming? But I need some help there, Mr. Whitaker.
Okay, so before you joined us tonight, Gary, I went over briefly, and the questions you've asked is very good. I went over briefly what this application was about. The first question that the board must answer is whether there is a non-conforming use, meaning a use that pre-existed the zoning ordinance. Now, listening to the testimony tonight from Mr. Ruse, I would suggest to the board that the second question would be the scope of, if you find that there was a non-conforming use that was granted, the second question will be, what was the scope of that non-conformity? We've had some phrases that are words of art, a nursery and a garden center. We need to determine what the scope of the nursery and garden center was and would continue to be and would be permitted as part of the non-conformity. For instance, Mr. Roos referenced in his discussion that everything that was sold there was natural. He also said that there were no power tools or power equipment sold on site. So some garden centers do that, as you know, but this garden center never did. So that would become, if somebody came now and attempted to do that, that would be considered an expansion of the nonconformity, because it's not things being sold there that would be of the nature of being, as he used the word, quote, natural. The third question that has to be resolved by the board, if they find that it is nonconforming and they have then defined the scope of the nonconformity, that third question is, has that nonconformity ever been abandoned? And there is a litmus test for that abandonment. Mr. Garibaldi, I'm sure, is aware of it. The most famous case that's been recited for many years, the case goes way back, it's the Saddle River case about the abandonment. I've actually taken you through that case when you've been confronted with other issues of nonconformity in the past. So those are the three issues that need to be addressed. From the testimony that I've heard so far, the testimony that's been proffered so far addresses the applicant's position about the nonconformity. And I can give you more references of that in a little bit when I make some comments about that prior resolution. The second aspect that the board still needs to define and delineate, if they find affirmatively that there is a nonconformity, as I said earlier, would be the scope of it. And then the third would be the abandonment. And that's an issue I think Mr. Garibaldi still needs to address. He's referenced it a bit, that it's been continuous. There is at this point, there are some trucks there that have tenants, as he testified to. He's parked vehicles in the back. There's no active sale of the material, I gather, at this point. That's something that needs to be developed first, but we have to take it one at a time. So I think now the board really wants to explore and just ask the questions about the nonconformity aspect. And I think, Mr. Chairman, if there's no more questions by board members, then I think it would be appropriate for the members of the public, if they have questions pertaining to the nonconformity aspect. I don't think you get to number 2. I know you don't get to number 2 about the scope of the nonconformity unless you first find out there is in fact a nonconformity.
Thank you. Do we have one other board member who may have questions? Mike Pickholz, I didn't ask you.
No, I'm good at this time. Thank you.
Okay,
Mr.
so
Chairman, can I just interject for 1 second? Just
Yep.
to clear up a quick question that one of the board members mentioned, that Mr. Wiggers had left the site in 2012. The testimony was of Mr. Roos's that he left in 2019, not 2012. So he was there for about 8 years. I apologize. I just didn't want that to carry over to the public.
yep, I just want to write that in my notes. 2019?
Correct. About June, I think, 2019.
All right, if there are no other questions by board members, we're going to move on to questions by members of the public. If you're a member of the public and you have a question, not a comment, a question, now is the time. Please raise your hand and Dylan will let you in.
All right, I'm
And
ready.
the question should be limited at this juncture as to the issue of whether this is whether the use is a non-conforming use. Questions pertaining to the scope of it and questions pertaining to abandonment would be asked at a later date when we revisit this.
I'm bringing in the first person, Jacqueline. She'll be in a second. Please unmute and turn on your camera.
Hi.
Good evening.
There's actually 2 residents here, but I'll speak first.
We need full name and address.
Jacqueline Hone, 30 Carriage Lane, Ridgewood, New Jersey.
So your last name, please.
Hone.
Thank you. Address, I'm sorry, I missed it.
30 Carriage Lane.
Thank you.
I'm a little unclear about what I can ask and what I can't ask. I'm sorry. I tried to follow, so I apologize if I say something I shouldn't be saying and need to say at a later date. As far as the application itself, I know that it started off by saying, and I'm not sure about this, the information at the first hearing is not being considered in this.
This is a fresh new application. Nothing from the first hearing is being considered. There was issues pertaining to the first hearing about the proper notice, et cetera. So this is a, if you will, a do-over. There was never any decision made. So this is a restart. And so everything that we have to consider will be what's presented now.
Okay. That the documents that are up on the village website pertaining to this matter, that application is dated 7/1/19, so that's still okay, correct? The information in those documents?
Yes. It's documentation that's got a historic nature to it.
Okay, and the questions that we are speaking to right now were for the conforming use?
That is correct.
Okay. In 2010, 2011, there were numerous citations and violations of the Village of Ridgewood to the property occupants and Mr. Roos as well. What changed during that period of time that Mr. Roos began to have a bunch of violations for non-conformant and expansion of use? The application has several
All right,
exhibits.
that's a question for Mr. Roos. You've asked one question. Let's have him answer them one at a time. Mr. Roos, the question, if I can frame it, is there was a series of complaints that were issued in 2010 and 2011. What were those complaints pertaining to, and what modifications were made to the use of the property based on those complaints, if any?
I'm not aware of what the complaints were at that time. If you could address what they were, I might be able to give you a better answer.
Sure, part of the exhibits submitted is an actual testimony on your behalf and a transcript of what you had said in court. I can look up what that exhibit is. It outlines a court proceeding that you had with Judge Fund at the time.
Yes, I did go to.
So you submitted those. You submitted those exhibits. They're up on the website. I have a list of some of the violations. I can read them to you, but I'm uncertain as to, and you pled guilty at the time. I would just like to clarify, if you can, please clarify for me what took place at that time that you received all these violations and pled guilty to expansion and not conforming use.
I'm here again. I'm not aware of the expansion and non-conforming use. There might have been a violation as far as trash or other things that shouldn't have been left on the property at that time. But here again, I need some clarification on that.
If I just stop for a second, Mr. Garibaldi and Mr. Roos, does Mr. Roos have the list of the exhibits tonight to reference?
He does.
Okay.
But if I can, if he's having trouble accessing it, on page 4 of the court proceeding, the 4 complaints, there were 4 special complaint summonses, and I'm reading. One was for a stagnant order allowing mosquito breeding, a complaint for a violation of unsanitary conditions, and a failure to remove debris, and last was a storage of commercial storage vehicles. And there was a motion that was made and accepted by the court that everything but the commercial vehicle storage was withdrawn by the village. That would have been the non-conforming expansion, and there was a guilty plea on the other 3 that I cited above, which again, the guilty plea was for the stagnant order of mosquito breeding, violation of unsanitary conditions, and then the failure to remove debris. But the allegation of an expansion of a nonconformity was dismissed by the village. So there was no guilty plea on that.
Okay, that was for 2011, correct?
Yes.
There were also numerous, they weren't submitted in the exhibits, but I have records and knowledge that the violations continued up until Mr. Wiggers left the property, which was 2019.
Right. Now, are these violations against Mr. Roos or against Mr. Wiggers? Because I'm not aware of any others against Mr. Roos.
They were, I believe, both. And I believe that in the last hearing, but we're not going by that, Mr. Roos clarified some of them.
Ms. Hone, do you have those documents that you can use as an exhibit?
Yes, I tried to submit some information earlier today, but unfortunately I was told that I had to submit them 48 hours in advance. I do have lots of documents showing pertaining to non-conforming use, abandonment, and what the space is being utilized and what it was utilized for.
Okay, so you have the ability, after the applicant has completed their case, to.
I'm sorry, can you repeat that?
I'm sorry, after you have the ability and the right, after the applicant presents their case, to bring forth testimony and exhibits to dispute the applicant's position. So my recommendation would be that you put together your list of exhibits, and you would be able to testify to those exhibits when you present your case in opposition to the applicant's case.
Okay, would that have to be
My impression is that will not occur tonight.
correct?
But then you have to take your exhibits, and they have to, by the new rules we have based on COVID-19 and virtual meetings, those exhibits have to be posted 48 hours in advance of a hearing. Now,
Okay,
members of the public are not aware of these rules and regulations that came down last year. And the basic concept that has been used is that since the public is not aware of it, and that it has to be posted 48 hours in advance, the public is given the opportunity to post them, and a hearing is carried to another meeting for that purpose. So that is what can be accomplished here, so that the full hearing occurs.
thank you. Yes, I wasn't aware of the 48 hours.
That's a very prevalent, not mistake, but very prevalent issue that comes up with these type of cases. So the general consensus amongst land use people working through these rules is that since the public's not aware of the 48-hour rule, they're given the opportunity to correct that by presenting their case at a subsequent meeting.
Thank you. So I do have information pertaining to that I can.
So you can prepare your case for that purpose. Do you have any questions right now pertaining to the nonconformity aspect of this witness?
Yes, Mr. Garibaldi mentioned something about there are images of the property dating back to the early 1900s.
I believe it was 31. That's A12 of the exhibits.
A12, okay. A12. I could just write that down 1 second.
Mr. Garibaldi, that's on the exhibit list that you posted, right?
Yes, I did. It's of the 15 that it's A12.
Yeah.
I'm sorry, yes, A12.
Are there any other photographs? I'm sorry, I didn't see that. Photographs recently, like 20?
No, these are historical. The most
Historical.
recent, I mean, what's been going on since '99, we didn't believe would require a photograph. That's again trying to show the historical purpose of the vacancy of this property as far back as we were able to get access to.
Okay, and I would also I will also include in my exhibits photos from 2006 to present, because it tells a very different story. But I'll be able to testify on that once I submit my exhibits, because at the moment, me just saying it, I think it'd be more impactful and credible for you to actually see the images than me stating anything. And right now it's just questions, correct?
That is correct.
Okay. Then in regard to the non-conforming, those are all the questions that I have.
Thank you. If there are any other members of the public that would like to ask a question regarding the pre-existing non-conforming use that the applicant has testified about, please raise your hand and then we'll let you in.
I'm not showing anybody else.
No one else. Okay. So Bruce, do we move on to?
conclude with that part. Mary Ann, do you have any questions? Our planner. You're muted.
Yes. I do have a few questions, just general. I'll throw them out there and maybe they may not be able to be answered at this point in time, but you can think about them. Yes, the first question is, will you have a planner testifying?
As a future application or use, this is a certification of prior uses and for the pre-existing non-conforming current use. What would the purpose of the planner be?
Well, is there someone that is going to address my report?
I haven't seen a current report. All I have is the borough village engineer. I didn't see anything unless I missed it.
No, my report was submitted with the original application, and it hasn't changed. So it was, I mean, I have it here.
It dated September 12th, 2019.
Yeah. Yes, thank you. Yeah. So I think that's important because I've raised, I think, many things in there that should be addressed by the board. And I know you have apparently at some point in time, someone involved with the application saw it, because one of the first things I asked for was documentation and photographic documentation and testimony on the use itself. And you've obviously made the effort to provide that. But some of the other questions, which I think are very important in that report, haven't really been addressed yet. So I just wanted to just throw that out there and ask that. I also have did a site visit today, so I can get a current impression of the site rather than from when the original application was made. And I have photos as well that I guess I will pass along so that they can be added to the record for any future hearing. Obviously not for today. But I guess the first question, to kind of put this in perspective a little bit, is I've heard a lot about what this site used to be, and it was a nursery, and there was landscaping sold, and it was, I have garden center and nursery. So there were plants grown and plants sold. And then it seems as though it may have changed over time into a landscaping. Well, it seems what's out there now is definitely not a nursery or a garden center. What's out there now is a landscaper's yard. There's mulch piles, there's stone piles, there's pallets, and there's a vacant building that looks like a place where things used to be sold in, and there's a couple of other sheds and trailers on the building, and there's equipment parked in the back, but there's no current nursery operation. And I'm really not hearing anything that deals with that, and there seems to be a disconnect there. So I guess I need an explanation of what you're getting at with this interpretation request, because it does seem that it's no longer a nursery.
Well, can I just real quick, we started this application about a year and a half ago. And then we as Mr. Whitaker indicated, there were some notice issues, but and then we hit the pandemic. This property has been under contract for 2 years. Mm-hmm. Mr. Wiggers was removed by another litigation. Our intent was to close. We signed a contract that was indicating a 3-month close date from, I believe, January of Mr. Roos, just correct me, I think 2019 was the date, and we were anticipating a closing date 3 months thereafter. Buyers council properly requested that we obtain this certification. And so this lapse in between was to obtain this, and we were significantly delayed. And I'm not, everybody blames the pandemic for everything, but this truly was the inability to return, because the buyers did not want to have a Zoom meeting for these proceedings and preferred having in chambers visit, but that is not working out. And as of December of 2020, they acceded to us now reappearing back to the board. So there was no, the timeline is merely because of these administrative issues, nothing to do with the village, but our inability to return and complete this process. But we had taken the steps per the contract to make the property accessible to the new owner to undertake this new venture, and the removal of Mr. Wiggers and ultimately the people that are there now is part of our contractual responsibility.
Okay,
Right.
then a follow-up on that then, which is another clarifying question, for clarification, and just to make sure that I'm on the same page and I understand exactly what you're proposing. They're still the contract purchaser, and they want to be certified for a nursery. And you're looking back at the prior application to say they were certified they did receive that certification, and they then went further and received a site plan approval. Based on my review, it appears that site plan approval and the variances granted with that site plan approval expired.
Right.
Because that was not implemented.
I would
But
make one clarification there.
Mhm.
And that is, if a use variance is approved, Mary Ann, you know, that runs with the land, but you are
Yes.
correct. Site plan and the bulk variances that they were granted, those have all expired. There's no question.
Okay. And that approval, when I look at the details of it, does not talk about storage of landscaping vehicles and other things. It's a site plan for a nursery for a specific, and it has a site plan improvements with it. It doesn't have that additional parking or storage for nursery vehicles or landscaping vehicles. So the new user, I guess, contract purchaser, is specifically in their letter of request is looking to have that included as well. But clearly that wasn't in the past application. So I think there's a disconnect there, because even if it was certified as the one nursery use, it wouldn't have had the vehicles associated then later on. So I guess I'm as you go forward, I'm looking for clarification of that. And those questions are also included in my review.
Okay. It seems like we're planning to come back, so I don't want to, not give the respectful response. And I'll speak to Mr. Roos because I will have a more exacting response to those good questions for the next go round. And Mr. Whitaker, I would reserve the right that if necessary to bring in a planner to specifically address the village planner's statements and comments and questions that she had this evening and are referenced in her report, which again, that I'll just reserve for if we're coming back, I would reserve the right to have that opportunity.
You certainly have the right for that. Yes, there's no question there's going to be a second meeting.
Yep.
Okay. Anything else, Maria?
No.
Mr. Rishauser, do you have any questions?
Yes, I do. I have a number of questions. First one is a simple bookkeeping one. On the application before the board tonight, it lists the property as lot 6.0. Yet the survey listed lots 6.01 and 6.02 because it was subdivided, I think, in 1988. Could either the applicant or the applicant's attorney clarify exactly which parcel is the subject of this nonconformity application?
Yeah, the property was subdivided in 1988. According to my tax records and everything else, it is listed as a property in question. The nursery is 6.01.
So this application only deals with lot 6.01.
Correct.
Okay. All right, and on the recently submitted survey by Lepatka Associates, on the eastern portion of lot 6.01, there is a 15-foot right-of-way that extends to West Saddle River Road. Is it the intent of the nonconformity use to be able to use that right-of-way for egress to West Saddle River Road or not?
No, it never was and never is. As far as I ever knew, it was for public service to have the right to egress that section. Public service, gas, electric.
So that's all, so you're saying that's only a utility easement,
Correct.
not an egress easement?
Correct.
Okay.
Mr. Garibaldi, I think it would be wise for you to find that documentation and submit it.
On the right of way?
Yes.
All right.
That would be very good, Mr. Whitaker, because the property can change considerably in its use if egress is going to be taken out to West Saddle River Road.
Understood.
Another question is, you mentioned that the property has been utilized as a nursery for an extended period of time, Mr. Ruse.
Yes.
Did you ever get an SIC number for the property?
What is SIC? Just
Standard Industrial Classification. For a nursery, it would be 5261.
I'll have to talk to Mr. Garibaldi about that. I had permits from the state of New Jersey in order to operate as a nursery. I had to renew those every year.
I do not recall seeing those permits as part of the packet that was submitted with this application for tonight.
Okay, I'll have to get you copies of those.
That's it for this. That's it for now. Thank you.
Thank you. 1 second here. Okay, I just want to make sure we don't have any other members of the public that have any additional questions. Dylan, if you can take a look.
No, I'm not showing any other hands being raised.
Okay. And I just also want to make sure that based on what we've heard, there are any questions by board members.
Yes, Mr. Chairman, I have one that's come up now as a result of the testimony, but it was my earlier concern as well. With the parked vehicles, each of the decades listed on the occupancy has multiple people, and they would have vehicles that belong to them, but there was also testimony about commercial vehicles being parked there. So while vehicles that belong to the tenants can park there, perhaps regardless of their registration, I'm questioning whether allowing other tenants with commercial vehicles to park on that is accepted and is part of the non-conforming agreement that existed with the owner. That's a gray area for me, whether other tenants can park commercial vehicles that are not of any connection to the ongoing business, which may have its own commercial vehicles. I would like some qualification and clarification on that for what has happened and what is currently there. Thank you, Mr. Chairman.
Thank you. So Bruce, we've arrived, I think, at an inflection point here.
Yeah, let me probably, give me a couple of minutes here. I'd like to break this down. You know the three questions that I say the board is being presented with. So let me just give you an overview of what we have so far. And perhaps board members, members of the public, based upon the comments and the information I'm going to supply, you'll have the ability to do some, and the applicant, excuse me, will have the ability to do some further review to address these for our next meeting. The first question is the question, as I said, pertaining to the certificate of nonconformity. And I would suggest that board members, members of the public, look at the resolution that was shown earlier. And that resolution of July 14th, 1999, They did not ask for a certificate of nonconformity. They asked for an expansion of a nonconforming use. But there are findings of fact in that resolution by this board, not you, but prior members of the board. And that has to be looked at, and you know what the term res judicata means. So that's something for you to look at. Read the whole resolution. I would suggest that paragraphs 6, paragraphs 7, and 8C, page 8, paragraph 2A. When you say you're seeking an expansion of a non-conforming use, that they were at that point acknowledging that a current use was non-conforming. So just look at that very carefully in connection with your analysis. There is a recitation in that resolution on page 9, paragraph 6A. There's a recitation by the board. The use has existed on this site for almost 80 years and is without contest that the use is non-conforming to current zoning regulations. So I want you to look at that in connection with the relevancy of the questions being posed to you, that is this a non-conforming use? Has that determination already been made? Now, the second thing that needs to be looked at is that, I said it earlier, it's words of art. It's garden center and nursery. Those are the three words. We'll break them down: garden center and nursery. In all of the information that we have here, and you have to look at a definition of garden center and nursery would be what your common sense would consider it to be. I've already stated earlier, Mr. Roos has commented that, you know, power equipment was not sold there. There are garden centers that do that. Everything here he stated was natural. So I think what you have to look at when it comes to the vehicle storage aspect is that at the time that 1999 resolution was being presented, what was being looked at then was vehicles that were used in connection with the nursery garden center operation that existed there. So I think if you find it's non-conforming as a garden and nursery center, what you're looking at are vehicles that were used in the operation of the garden and nursery center. Meaning that if there was a pickup truck there that delivered shrubs, delivered perennials, if there was a type of motor vehicle that was used to move mulch on the site, to move topsoil, to dig holes, whatever else, if it's part of the operation, that's one type of storage. But I think you've got to go through the record to see if there was ever any type of nonconformity that existed before the ordinance that allowed commercial vehicles not an integral part or related to the nursery or garden center operation on the site. Was that ever a non-conforming use on the site? My review of the 1999 resolution, I don't see that indicated. And so that's a finding of fact you have to review and make, and that's something the applicant still needs to address. You know, there are garden centers, you all know, that offer services from the garden center themselves, whether it be to deliver mulch, whether it be to go out, maybe even cut lawns. But I think that's different than commercial storage of vehicles that are not related to the day-to-day retail and wholesale operation of selling nursery or garden center products. So I think that's what needs to be framed. And then finally, the other thing I would suggest, and I will do a memorandum on this, but as far as abandonment is concerned, there are two major cases to look at. I will give you a memorandum referring to them, but council, I want you to be aware of them. I'm sure you know of them. Berkeley Square versus Trenton Zoning Board of Adjustment. It's 410 NJ Super at 255. That's a 2009 case. But the case that goes back further than that is the Borough of Saddle River. It's the Bobinski case. I think I can come up with a citation. That's the horse barn case.
Yep.
And that's the one that's always used when land use is taught.
Right.
And that's one that needs to be addressed and looked at. When I do a memorandum on this, I will send it to the board members. just as an outline. And I'm going to ask that the memorandum that I do, which is just to outline these three things, and I'll reference those things, members of the public will also have the ability to look at those citations so that we're all, so to speak, on the same page. So that's just an overview of where I see this application going. What we need to do now is to select, Mr. Chairman, the next hearing date for this. I think with the fact that we will have all of the exhibits in front of us, that it would, Jane, require a full night to get through all aspects of this. So I'll let you make that determination.
Thank you, Bruce. Very helpful. Jane, what do we think?
May 11.
Mr. Garibaldi, May 11th work?
We'll make it work.
Ms. Hone, you have the ability to have all your exhibits and everything lined up and ready and available for May the 11th?
Again.
She's still there? I didn't see her.
Yeah. Dylan, let Jackie back in. Okay.
Bringing her in now. Hold on one second. There she is.
Ms. Hone, you heard my comments?
Yes, I heard them. May 11th is fine. And I just, if I may ask, the question in regards to the commercial lease, Mr. Papietro, I'm sorry if I butchered your last name. I don't mean that too. Is it possible, Mr. Roos said that he currently has 3 tenants, commercial vehicles parked in the back. There's a verbal agreement. Is there a way to have that information provided as to who they are, an account, some type of testimony from Mr. Roos that these are the people that are now in the back and to what capacity and who they are?
Absolutely. That's something that the applicants can certainly proffer.
Thank you.
So Bruce, and this is for you, Ms. Honey, you 48 hours prior to the meeting. So the 11th, so that's a Sunday. Is that okay, or do we want to do the 5?
I mean, you have the ability to list exhibits 48 hours in advance, but with the amount of time that's involved now, my suggestion, and just so that all board members have the ability to look at these exhibits in advance, even though technically you only have to do it 48 hours in advance, my recommendation would be that everything should be in by the Thursday before the Tuesday meeting. Does that present any problem for anyone?
Not for us.
Okay. Ms. Hone?
No, that's fine. Can I just get clarification on that? So May 11th is the day that there will be a next hearing?
Correct. At 7:30 with no further notice.
Hearing, and then 2 days prior to that, all exhibits would be made public?
Well, they have to be posted within 48 hours of a hearing, but as the chairman stated, that's a Sunday. So the concept is that the members are going to want to review these exhibits. So if we want to use our time expeditiously, I'm suggesting that all the exhibits should be sent in and get posted as early as possible, but no later than that Thursday before. They're not going to get posted on a Sunday, okay? So we don't want to come to another meeting and then find out that we have to go again because the exhibits weren't posted. So I'm suggesting both the applicant, who consented already, as well as you, that any exhibits you want posted, supply them that no later than that Thursday before the public hearing.
May 6th.
Okay. And
Okay, because
what
if
was
you
that
don't
date?
do
I'm sorry,
that,
Jane.
because now that
6th.
you can put on
May
notice of it, Ms. Hone, now that you put on notice of it, if you say, oh, I've got more exhibits I never posted, the board does not have to consider them at all. They can move on.
Understood. So May 6th. Submitted by May 6th.
Correct.
Okay. Thank you.
Mr. Garibaldi, any questions as to next steps, or we're good to go for May 11th?
No, I think I'm fine. Thank you.
All right, great. So May 11th, 7:30 PM via Zoom. No further notice required.
Serge, if I
Yes.
may. Along the lines of what Mr. Whitaker was saying, I found that the transcript of what led to the resolution of 1999 was extremely informative as to what the board members were considering, what they were for, against, whatever. I just found it very informative and might apply to some of the issues that have yet to been discussed in detail.
You are correct, Gary. And incidentally, Gary, you just need to sign a certification for that part of the meeting tonight you missed.
Yes, I will get the recording and go through it.
Thank you.
I noted you came in at 7:55, so unless you want to continue listening, you don't have to beyond that. All right, any other board members, or we can let the applicants go?
We're done.
All right, we'll see you May 11th.
Great. Thank you all.
All right, good night. And since we did the resolutions at the beginning, I don't think we have anything else. So we can, unless anyone has any discussion items, we'll entertain a motion to adjourn.
Motion to adjourn.
All right, all in favor?
Aye.
Aye.
All right, thanks, everyone. Jane, Dylan, Bruce, take care.
Good night.
Have a good evening.
All right, bye.